I'm a volunteer lawyer with Maryland Volunteer Lawyers for the Arts. It is my sincere honor to be here speaking with you today, and I will be doing a presentation on behalf of MDVLA called Copyright and Contracts 101. Next. Now, here's a little bit of a disclaimer. We just want to make sure that everyone understands that the opinions and conclusions in this presentation are solely those of the author, unless indicated otherwise. This presentation provides general information and is not intended to be and should not be taken as legal advice. This presentation is not intended to and does not create an attorney-client relationship. Legal advice must vary with individual circumstances. Do not act or refrain from acting on the basis of this presentation without consulting professional legal counsel. Contact Maryland Volunteer Lawyers for the Arts when you come across these issues. Thank you. Next. Now, what is a copyright and when do you get it? Well, I'll answer the second part first. You get a copyright when you fix an expression in a tangible medium. Next. Now, what comes with copyright? Well, copyright holders or owners of copyright under the Copyright Act get 6, count them 6, exclusive rights. They get the rights of reproduction, modification, distribution, performance, display, and transmission. Next. Now, what about these 6 rights? How long do they last for? Well, the length of copyrighted works made after January 1st, 1978 are as follows. It's life plus 70 years for individuals, 95 years from publication, or 120 years from creation for corporate authors. Be mindful, authors can license, which means provide a limited right to use for another person, or assign, which means transfer all of their rights, meaning so you can give a limited right to use your work to someone else, or you can decide that you would like to give all of your rights to another person, or sell them rather. Next. Now, there are these concepts that all artists, whether you're a visual artist or a musical artist, should be familiar with, and that is the work for hire agreement. If you are an employee, your employer owns the copyright, likely because you've signed a work for hire agreement. If you are an independent contractor, however, you retain the copyright in the works that you produce unless you've signed a work for hire agreement. And authorship, which is ownership of copyright, can come in the form of co-authorship. And co-authorship can be joint authorship, whereby a work was created by 2 or more artists who intend to merge their contributions into one work. Now, co-authorship doesn't have to arise and doesn't necessarily arise from a written agreement. Co-authorship may be inferred from conduct. So if 2 people are working on a sci-fi novel and one person comes up with the dialogue and another comes up with the settings and the characters, there might be an inference that them working in concert and producing independently copyrightable creations that they have created a work of co-authorship, joint ownership. Next. Teaching artists. Okay, so we always want to teach artists about how they need to think about copyright. One thing artists need to think about is copyright registration for their works. They also need to think, and you can call up in MDVLA if you have a question. Artists need to think about how to properly negotiate copyright licensing agreements to adequately compensate them for their labor. Finally, as an artist, you need to know that continued use of your materials or recordings should equal more money for you. Next, we cannot stress this enough. Artists, register your work. Please visit www.copyright.org. That way you can see the schedule of fees for the different classes of copyrightable works and how much it costs for registration. The Copyright Office also produces these amazing, not dry, but super informative circulars where you can learn about discrete copyright topics like joint ownership, or you can learn about the registration process. And they make it really clear, and they provide links to forms and explain them. It's really wonderful. Now, what do you need to register your work? Well, you'll need proof of validity. You'll need the date in which you believe copyright protection began, like the date of creation. And you'll also need proof of ownership. These are required to bring a lawsuit because these are necessary for registration. And to bring a lawsuit, you'll need to, particularly for infringement, you will need to have that work in question registered. Registration is required for statutory damages and attorney's fees. And this is only if the work was registered prior to the alleged infringement. You may also, as an artist, do pre-registration. There is also a process regarding the registration for unpublished works. So in the general sense, works that you have not made available to the public could be considered unpublished. And so you have a certain process and there's a certain fee schedule for unpublished works. Next. Now, copyright processing time. Okay, folks, we all know that the wheels of government move really slow. So as a, artist, musical, visual, performing, you'll need to know about the processing times for registration. Okay, so here it is. So claims that do not require correspondence that are sent in electronically through the Copyright Office's web-based filing system take an average of about 3 months. Claims that do not require correspondence that are submitted to the Copyright Office via mail take about 6 months. Claims with correspondence that are processed through the Copyright Office's e-filing system take about 6 months. And claims with correspondence that come in through the mail, those applications for registration take about 9 months. Next. Okay, so this is the big one, copyright infringement. We hear about it on the blogs or read it in the trades, like someone's taken someone else's work and put it on a t-shirt or a mug, or they've used someone's artwork in a movie or a television show without permission. These are all examples of copyright infringement, meaning you have infringed upon one of the exclusive rights held by someone else. Now, what are the requirements for copyright infringement? Well, it requires either copyright registration or refusal from the US Copyright Office to register a work. You'll also need to show proof of ownership of your valid copyright as the work's author. You'll also need to prove the elements of some of the tests for infringement. Across our great nation, the federal court circuit, the system is divided into different circuits. And each circuit and its district courts may have different tests for infringement. So, but there are some common elements across the circuits, and the Supreme Court has ruled in enough copyright cases to kind of give a general sense of what is required to show infringement. What are the elements? Well, one of the common elements is access. So let's say you're a painter and you have a social media platform that you post to, let's say Instagram, and someone you allege, took one of your most famous paintings and decided that they wanted to, I don't know, put it on a yoga mat or put it on a sweater for dogs. You'll have to show access. Well, you have a public page, and there may be proof that this person is a follower of yours. That might be enough to show access. Another common element that you'll need to show is substantial similarity. Now, substantial similarity is one, different circuits have different interpretations of what that means and additional requirements, but essentially substantial similarity is that it's demonstration or showing that the author's work and a subsequent work or contemporaneous work are substantially similar, that there are enough commonality of the elements of the two works to show that the older work was infringed by work either created at the same time or another work created later. Infringement also requires a showing of damages. And to show damages, you need to establish a connection between the work infringed and profits. Finally, copyright infringement may entitle a plaintiff to statutory damages if eligible. Next. Okay, this is another one. So if you don't want to infringe on someone's work by using without permission and infringing on any of their exclusive rights, then you will need to rely on the defense of fair use. So fair use is essentially, it's not complete. There are parameters and limitations to fair use, but if successful, fair use will allow for you to use a portion of someone else's copyrighted work for incorporation or use into your own. For you to avail yourself of fair use, your use must be for purposes of criticism, comment, news reporting, teaching, scholarship, or research. Now, there are 4 factors, count them 4, of consideration that you need to be aware of when you are determining whether your use may be fair. The first, the purpose and character of use. Second, the nature of the original work. Third, the amount or substantiality of the work, of the original work used. And finally, the effect of the use on the market for the original work. Next. So, what's a contract? Well, for you to be able to sign or give a license or receive a license for the exclusive rights of afforded under the Copyright Act, you'll likely need a contract. A contract consists of the following elements. An offer. I offer to sell you this pen for X amount of dollars. Acceptance. I accept your offer to buy your pen for X amount of dollars. Consideration. Consideration, it varies, but essentially consideration is you promising to do something or not do something in order to bring about the contract. Now, does a contract need to be in writing? Not necessarily, but it should. Be mindful though, there are instances where a contract must be in writing, and it conforms to what's known as the statute of frauds. Every state has a statute of frauds, and it lists the types of contracts that must be written for them to be effective. One type of contract that must be written in order for it to be effective is the sale of a good, like artwork. And the sale of that good, for it to be effective, for a contract regarding the sale of that good to be effective, the good must be over $500. Another type of contract that must be in writing is one where performance cannot take place within 1 year. The second type of contract is another one of the contracts that is required to be in writing because of the statute of frauds. Next. What are some typical contract terms? Well, parties, which are the individuals or organizations, corporate bodies that essentially form the contract and have their rights and responsibilities spelled out within the contract. The next is rights granted. So what are the rights that are granted to each party? The term. What's another contract term? Territory, compensation, payment, expenses and advances, accountings, termination, warranties and representations, and indemnification. Next, rights granted. Okay, so what are you specifically allowing or disallowing under this agreement? Are the rights exclusive or non-exclusive? Remember, there are 6 exclusive rights. And so you can think of it in this way. So when we talk about exclusive rights, someone may, as a rights holder, keep all of their rights, and they have the right to reproduction and transmission. But let's say that that person decides that they want to make money through a license. They can issue what's known as non-exclusive licenses to other individuals to use the work in a particular way that, doesn't interfere with the original rights holder's use of their copyrighted work. So for example, Disney may have licensees or give licenses to companies, apparel companies, educational tech companies, to use their characters in a particular way. So each one of those individuals has a right to put Disney characters on their products or advertise using Disney characters. And those uses or don't interfere with one another. There are specific rights that attach to the use of artwork. And there's one law in particular that governs artwork specifically, called the Visual Arts Rights Act. And the Visual Artist Rights Act. Visual Artist Rights Act essentially gives what would in Europe be called moral rights, meaning the rights of the artist to control the integrity of their work. So VARA doesn't apply to all types of visual arts, but it does apply in situations where there might be a limited run or edition of a particular work, and it applies to large like public art installations or large murals or works of street art. So there's been a lot of successful litigation regarding graffiti artists who have claimed VARA rights in the murals that they have painted on the sides of buildings, And in instances where those have been whitewashed or removed, they've been successful at getting damages under VARA for the for the for the integrity of their artwork being damaged by another. Now, are there other rights you might be worried about? Well, one thing you might want to worry about is, do you want to show the work ever again? So that might be something you might be mindful of. You might not want to give up the exclusive right that allows for you to display that work. Another thing you might be concerned about is the control of your likeness and publicity. Likeness and publicity laws are creatures of state law. So each state has slightly different limitations and scope for likeness and publicity. But if you're a famous artist and you don't want to remain anonymous and you like to be associated with a particular medium or type of work, you want to be able to control the use of your image or approximation of your image, as well as your public persona, which publicity protects. Also, artists need to be mindful that selling their individual artwork does not mean that they're giving up copyright. But in order to prevent this, in order to make it clear, you want to put this in writing, that by selling your individual work, you are not giving up any copyright, any exclusive rights to another person, to the buyer of your work. Next, and we're going to talk about term, compensation, expenses, and advances. Term. Does the contract last for a certain length of time, like in order to satisfy perhaps the statute of frauds? Or is the term of the contract come about through a certain number of actions? For example, an artist and a local government agree that the artist will do 6 public art installations. Next, compensation. What is the rate of compensation and how is it calculated? Is it hourly? Is it a fixed rate? Is it a formula? Is it a royalty? Artists need to ask, how much do they get and when do they get it? This is really important. This needs to be spelled out. And with regard to when you get it, you need to make sure that you understand that, because if your compensation is not forthcoming within a timely manner or within terms that are set by the agreement, then the other party may be in breach. Another thing that artists need to ask is, can compensation be refused? Also, they need to ask about expenses. Who is responsible for expenses? The artist himself might be. They need to ask about insurance, shipping, etc. Also, they need to ask about advances. Big question is, are there advances provided? Are they recoupable? From which profits can advances be recouped? Next we'll talk about accounting, termination, and warranties. Accounting. How do you know you're being paid the right amount? Can you inspect the books of your gallery or patron? Termination. When does this contract end? When do you get off the hook? What are the consequences if you end the contract before you have completed your obligations? Next, warranties, representations, indemnifications, and waivers. Warranties and representations essentially mean you guarantee the facts that you said are true and will remain true, like that you own all of the copyrights in the art you create. Indemnification means you will reimburse the other party for costs, damages, and losses incurred because of broken representations and warranties. And waiver means you can waive or essentially give away certain rights that you would normally have, but you must be careful. And please contact MDVLA to look at contracts and ensure that you are not waiving certain contractual rights. Next. Okay, so these are our big contract tips. If you don't take away anything from this presentation, which I hope you take a lot away from this conversation, from this presentation. First tip is put it in writing always. Don't rush. Try to be as clear as possible. Don't make assumptions about what you think the other person means. Keep asking questions if things are unclear. The next is one of the golden rules that our grandmas and moms taught us when we were little kids. Compromise. The art of compromise is so important for both parties to feel satisfied with the agreement that they enter into, even if they don't get everything they want. The next is another thing that our moms taught us. Keep your promises. That's why it's helpful for the terms to be clear. This is for your benefit as well. Next, let the other person redline your agreement. Give them some time to review. They may have some concerns, and that's okay. Allow for them to annotate and make some notes and, underline some things that they're concerned about, because that makes for points of discussion that may make for a better agreement. However, you want to make sure that you stand firm in your rights, but also flexible. Not everything necessarily that you don't get has to be a deal breaker. And finally, please call MDVLA to have us help you look over your contract. It would be a privilege to help you and to answer any questions and give advice about what the contract is, what rights and responsibilities you have, and what ways the contract can be made better or more equitable. I'm going to end with our contact info. So MDVLA stands for the Maryland Volunteer Lawyers for the Arts. Our phone number is 410-752-1633. If you have any questions, we implore you to please send a message to our wonderful coordinator, Caitlin Brown, and her email is info@mdvla.org. Please check us out at www.mdvla.org. We have so many resources, slides, presentations, links for webinars, information about arts organizations in the area. There's like so much stuff on there that would be incredibly helpful to you. We invite you to check it out. Please follow us on social media. We're on Facebook at MDVLA, all caps. Follow us on Twitter at Maryland VLA. That's VLA, all caps. Also, check us out on Instagram at MD_VLA.